is a topic that I think is one of the most important topics that subrogation professionals will hear. Not because it's not important to understand how to handle a subrogation claim, not because it's not important to understand how to apportion recoveries in work comp scenarios, or how to and when to refund deductibles and property losses, or whether and when the made-whole doctrine, the common fund doctrine, or the economic loss doctrine will apply to prevent you from subrogating in the event of property damage involving, say, an automobile that burns up. Those are all important things. But recognizing subrogation and third-party liability is the linchpin without which none of the other things would happen. And this is my 28th year of litigation, and I started off my career, and I tell this little anecdotal story because it bears on the ability to recognize subrogation and third-party liability. When I started off in law school, like all other young skulls full of mush, I was destined to save the planet, to serve my community, do great things for the world. I promised that when I was done with law school, I was going to go and do pro bono work, and I was going to work for some environmental group, and you know, all of this stuff. And then when I got out of law school and I saw what my debts were, my school loans, my debts to my parents, my credit cards were maxed out, I did the free market capitalist shuffle, and I went to the highest bidder. Fortunately for me, I had done much better in law school than I had even in college. I was number 3 in my class. I was editor of the Law Review, and so I pretty much had my pick of jobs. The job I chose was with a plaintiff's personal injury firm at that time, associated with the law firm of John O'Quinn, Murphy, O'Quinn, and Cannon in Houston, Texas at the time. You may not have heard the name John O'Quinn, but if you're from anywhere else in the South, you will have heard of him. He was on the cover of Forbes magazine twice, and was perhaps the greatest trial lawyer to ever live. I say that because at age 60, he was tragically killed in a car accident last fall. John O'Quinn had more $100 million verdicts than any lawyer in history, represented 4 of the states in their tobacco litigation, represented innumerable celebrities, and he has a car collection twice the size of that of Jay Leno. He was quite a flamboyant man. He was top in his class at the University of Houston Law School, and I learned something from him that I want to try and teach you today, and that is, when you're trying to evaluate third-party liability, whether it's a workers' comp case, a property loss, an auto loss, auto insurance, or auto collision, you truly, the facts do matter. And of course, the investigation of those facts are significant. But quite often, you look to the most common denominator. You look to the common sense of the situation, and you look to the claimant. Many times, the worker in a workers' compensation scenario, and we do a lot of workers' comp per century, but the worker is the person who will make or break the case. And oftentimes, I would bring what I thought was a great case to John O'Quinn and say, what about this case? I mean, this guy's got brain injuries, and he's never going to walk or talk again. I think we've got great damages here. And he didn't even ask the facts. He said, what does he do? Is he married? Does he have children? Does he go to church? You know, what kind of a plaintiff does he make? And these are things that I think are invaluable and intangible variables that you must take into consideration when evaluating third-party liability. Having said that, when we talk about, we're going to talk just a little bit about workers' compensation subrogation investigation, because I want to use that to draw an analogy, even though we're going to talk about recognizing third-party liability in all cases. But I want to tell a quick story, and it's a true story. And if we do not recognize third-party liability, there is no chance for us to take action on it. There's no chance to send out notice letters. No chance for us to send a demand letter, no chance for us to make a recovery, to engage experts, to do investigation, to hire subrogation counsel. It simply evaporates. And one of the amazing facts that I always like to relate in webinars and seminars to clients when discussing this subject is the fact that the 4 largest subrogation recoveries we have ever had in the history of our firm have all been in files in which subrogation was marked as non-existent. The file was closed. 3 of them had memos in them in which they said, we've looked at subrogation, it doesn't look like there's anything here, or subrogation potential isn't good, let's close the file. And the fact that those 4 files would turn out to be the 4 largest recoveries, 2 of which were in the 8 figures, I think is very telling and gives us a peek behind the curtain at all of the money that we are leaving behind because we don't recognize subrogation and third-party liability. And I'm going to go back to the previous screen because recognizing subrogation and third-party liability, again, is the linchpin. If we don't recognize it, we can take no further action. But recognizing it requires a couple of things. And I would say 2 in particular. One is we have to understand the law. So we're going to today, in a rather short period of time, sort of go through a basic law school torts class, a first-year torts class, hitting the highlights and helping you, those of you especially without in-depth liability experience. I mean, I have clients who have law degrees, so I don't mean to be condescending or speak down to anybody when I talk about the basics of legal liability and tort law in this country. But for years, the insurance industry has been taking it on the backside when it comes to liability. Favorable tort laws, excessive verdicts, creative theories of liability, and even when liability is not good, just the cost-benefit analysis of having to defend files, we've really gotten raked over the coals in terms of liability claims. Well, my premise here today is that we, when we take off our claims hat and put on our subrogation hat, really must think, and act like trial lawyers. It's our job to put aside any prejudices we might have, any liability predispositions, any preconceptions, and really get to the nut of the matter and actually be quite creative. I'm not advocating that we take frivolous cases or cases which have no merit or liability whatsoever, but I am suggesting that a lot of times subrogation is missed because we have a defense myopia in our industry. And thank God we do, because that's our job. Limit liability. Look at a fact situation and pay out as little as possible. Find reasons to blame the injured party. Find reasons to blame the insured. That's what helps us stay profitable. And our shareholders require that we zealously and in good faith adjust claims with those premises in mind. But when it comes to subrogation, I would submit to you that we must take off that claims hat and put on the hat of the trial lawyer. I often tell my clients that we are trial lawyers. We are plaintiff's lawyers for the insurance industry. And that oftentimes puts us in a little bit of a rub because trial lawyers are the natural enemy of insurance companies. So subrogation in no small part becomes a strange bedfellow with insurance. But I'm suggesting that when we talk about investigating and recognizing third-party liability, that we actually put on our plaintiff's attorney's hat and start to think like a trial lawyer. Now, just a couple of interesting tidbits. Ironically, I'm actually a candidate for the 60th Assembly seat for state representative here in Wisconsin. My primary is April 5th, and I've already drafted tort reform legislation. Representative Jim Ott from the district just to the south of me took it to the House floor. Much of that was signed into law a few weeks ago. I helped write the law with regard to punitive damages and the interplay of alcohol and intoxication. And the reason I was involved is because Jim knows my experience, and although Jim, who was a weatherman here in Milwaukee for many years, has a law degree, he has not practiced law. And strange as it may seem, we have 2 lawyers in the Assembly right now. Lots of interesting things going on in Madison, which we won't get into. But but we also have another bill, which is to become effective on February 1st, which we'll talk about, that I had a hand in as well. And so there are a lot of good things going on in terms of tort reform to help us on the liability side. But if there are favorable laws out there for the plaintiffs, those favorable laws exist, and we should take advantage of them. Let me get to, oops, I'm sorry. Now, with regard to workers' compensation subrogation investigation, there are a couple of things that we should keep in mind. Early recognition of subrogation, as we've discussed, is important. Prompt investigation into subrogation is critical, and creative subrogation thinking is necessary. Without these 3 things, without prompt action on subrogation potential, without prompt investigation into that potential, and without some creative subrogation thinking, we are going to be leaving a lot of money on the table. And it's my proposition that subrogation is an investment. And there are some cases in which we simply won't know based on the employer's first report, based on an automobile accident police report, based on the employer's report, or something that's phoned into us and typed out onto a claim form on your computer screen. We won't know whether or not subrogation exists unless we take the time to do some investigation. With regard to workers' compensation subrogation, we have 5 basic questions that have to be asked. And this is a precursor to recognizing subrogation and getting into the tort laws that will be applicable to all lines of insurance: auto, property, work comp, even health. But we have to answer these questions for every claim. We have to know what our subrogation rights are. Now, that's a little bit different than understanding whether or not somebody who was rear-ended has a right to sue the person who rear-ended them, or whether or not if you have property damage to a 1995 Buick LeSabre because it started on fire while sitting in the insured's garage, whether or not you have the right to sue General Motors for that property loss, or whether or not the economic loss doctrine or the made-whole doctrine or some other doctrine is going to prevent you from recovering it. Knowing what your subrogation rights are, at least in the context of workers' compensation, is going to involve understanding, can you sue? I mean, here in Wisconsin, we have a right to sue as a workers' compensation carrier the third-party tortfeasor, just like the injured worker and his attorney do. However, in Alabama, that right is limited to 6 months after the statute of limitations has run. Now, those are very important things to know, because if the statute's run and you close the file because the 2-year Alabama statute has gone, well, you've lost that subrogation opportunity. In Alaska, you have the right to file suit. You have a subrogation right, but that right exists only after 1 year of the 2-year statute of limitations has expired. So if you're in the 2nd month of a claim, it's important to know that you don't have the right to pursue that claim. You can investigate it, and there are times when it may be wise to do so. Other states, you can do so, like in Arkansas, but you have to give 3 days notice. Some states allow all parties to file suit. In Delaware, you have to have 260 days notice. The state of Illinois allows both parties, but you have to do it 3 months before the statute of limitations runs. So there are substantive laws that govern whether or not we can subrogate that really go hand in hand with understanding whether or not we have a cause of action at all, whether or not a defendant is in fact liable. We have to know which third parties can be sued. And this again goes beyond simply the investigation and the facts. If an employee is climbing up a ladder at a third-party premises and falls, is he careless, or was there something about the design of the ladder that somehow played a role in the injury? If the manufacturer and designer of the building and the ladder have somehow been negligent, can they be sued? And if so, what are our obligations? What do we have to do to sue them? If the plaintiff's attorney representing the employee who fell off the ladder fails to file suit, and our subrogation rights are lost because he does not preserve the statute of limitations, do we have a cause of action against him? Those questions differ from state to state. In Alaska, you can. In Arizona, you can't. In Colorado, you can. In California, you can't. So there are substantive laws that, again, will overlay onto the tort laws that we're going to talk about here for the balance of this webinar that we have to be familiar with. And then, of course, if your employee is treating and then suddenly we discover that he's not calling you and bugging you every day for the indemnity, the wage checks, and you're wondering why, and you call him and you finally track him down and he's in the Bahamas and he's settled a nice third-party case, you want to know whether or not you can go after the attorney for converting those rights. Or if you have a gentleman who's stopped treating and it looks like the claim is just about resolved, and then all of a sudden he starts treating again, and it turns out that perhaps he became addicted to some medication, or a second surgery is needed because of some sort of medical negligence, you want to know whether or not you can subrogate against the doctor. In Arkansas, it's not determined. In California, you cannot. In Colorado, you can. In Wisconsin, you can for medical negligence. You cannot for legal malpractice. You also want to know whether you can recover against UM or UIM carriers of the insured or of the claimant, and it matters. Other questions like whether attorney's fees are owed and whether we get a future credit sometimes is more important than the actual claim itself. And those are things that overlay on top of all of the other questions before we even get to investigating and understanding the why. But before we get to investigation, I want to go back to the claims hat that we talked about earlier. I want to go back to the defense myopia that we have. And when you have a claim, I think a lot of times our gut instinct tells us, our first reaction is, well, this gentleman stuck his hand inside of the meat mixer, and really to unclog it, that was kind of dumb. Or he put his hand inside this time of year the snowblower, and it took off 3 of his fingers. That was really pretty stupid. Obviously, there's no subrogation in that situation. I want some bells to go on in your head when that happens, and to really sit back and think, is there some opportunity here that perhaps we're missing? If I asked you to give an example of a case which best exemplifies a frivolous lawsuit, what comes to mind? Chances are that a lot of you have thought about the McDonald's hot coffee case. And that case in particular, I think, is very illustrative of the hat that I want you to wear when you're looking for subrogation potential. And I'd like to just talk for a moment about it, because it's one thing for us to go through this webinar and understand what you investigate, why you investigate, how you investigate, statements, spoliation. We'll talk about that. We'll talk about the new Supreme Court rulings on spoliation. We'll talk about the new legislation that's going to be effective February 1st of this year with regard to experts and how that affects you. But all of that really won't be as effective if you carry with you these automatic sort of prejudices that will prevent you from recognizing potential in the first place. Some years ago, I was practicing in Houston, and I was assigned a file by Hartford Insurance Company involving a gentleman who was working, and he was involved in a single car rollover. He was driving a Buick, the car rolled over, the roof collapsed, he broke his neck, and became a paraplegic who was unable to do anything except blink his eyes. I mean, it was pretty tragic. He also had some brain spastic quadriplegia from a brain injury, And about 3 months after that accident, I was doing some investigation. I hired an expert. We looked at the car. We determined that there might be some crashworthiness here. And again, we're talking about a case where a gentleman drives off the road. Don't know why, but it was only him. No one rear-ended him. No one pushed him off the road. No one ran him off. And subrogation potential looks rather bleak when you have facts like that. We're going to talk about some of those examples. Some of those may seem extreme to you as we get into these cases that look like they might not have subrogation potential at all. And in fact, if you pursue them, they might be downright frivolous. But in each of those cases, we made recoveries. And I want us to think like that, not because there's going to be subrogation in every instance, but because there is going to be subrogation in some of those instances. And those are the dollars we want to capture before they're left on the table. Getting back to Houston, I met with the widow of this gentleman who was, the wife of this gentleman who was injured, and she was still rather shaken, and she was meeting with me in my office, and I had brought in an attorney who I wanted to perhaps sign them up and represent them so that we didn't have to carry the entire bucket of water on the litigation, which was going to be expensive. And I brought in an attorney named Reed Morgan, who I know from Texas City, Texas, and he also has licensed in Albuquerque or in New Mexico. And she began to cry at one point during the interview and said, "I really can't do this. If I'm going to hire a lawyer, I want to go out and hire a lawyer that is just going to be like a Terminator. I want, for example, like that lawyer who handled that McDonald's hot coffee case. That's the kind of attorney I want representing my husband." And I turned to her and I said, "Ma'am, can I introduce you to Reed Morgan? This is the attorney who represented Stella Liebig, the 79-year-old grandmother from Albuquerque who was the plaintiff in that McDonald's hot coffee case." Within 5 minutes, she had signed up, and we made a nice recovery against General Motors after a few years of litigation in a case that otherwise would not have been recovered. We also got a very nice credit. And I want to talk, the facts of the McDonald's hot coffee case involve, this was in February of 1992. A lady named Stella Liebig ordered a 49-cent cup of coffee back then from the drive-through window of a local McDonald's. She was in the passenger seat of her own Ford Probe, and her grandson, Chris, was driving the car. They stopped at the drive-through so that Stella Liebig could add some cream. They went through the drive-through, and then they parked the car. He put it in park, and they were sitting still. And Stella Liebig, who was the passenger, wanted to add cream and sugar to her coffee. McDonald's requires their franchises to serve their coffee at between 180 and 190 degrees Fahrenheit. At that temperature, coffee causes third-degree burns to human flesh in 2 to 7 seconds. Stella's grandmother pulled that car forward and stopped the vehicle so she could add the cream and sugar. She placed the cup between her knees. She attempted to take off the cover of the cup in order to add the cream and sugar. The cup, the integrity of the cup had been affected based on the temperature of the coffee. It collapsed in her lap, causing and immediately soaked up her sweatpants and held the hot liquid against her skin, scalding her thighs, her buttocks, and her groin area. She suffered full-thickness burns over 6% of her body, including her inner thighs, perineum, buttocks, and her genital area. And she remained in the hospital for 8 days and underwent skin grafting and burn debride treatment. During that period, she lost nearly 20% of her body weight. She went down to 83 pounds and had a significant amount of medical expenses. What happened is she met Reed Morgan, and they offered to settle with McDonald's for only $20,000. She offered to settle with them for her medical costs, but the company offered only $800. And when McDonald's refused to raise its offer, they filed suit in New Mexico District Court, federal court, and they offered to settle for $300,000 at one point. The mediator suggested $225,000. McDonald's refused to settle. Discovery in that case showed that 700 other burn cases involving McDonald's and high-temperature coffee caused third-degree burns, skin grafts, hospitalization, and that despite knowing this, McDonald's had no intention of lowering the temperature of its coffee. The trial took place. The judge allowed evidence in that the plaintiff's experts showed that hot coffee served in most restaurants is about 155 degrees, and which is significantly cooler than McDonald's. But the McDonald's consultant said that serving coffee that hot created a different sort of aroma that lasted longer and helped with coffee sales. And during the trial, the quality manager for McDonald's, and this is what got the jury mad in that case. These are things that most people don't know when they hear about this case. And I know because I know Reed Morgan. But Christopher Appleton, who's the quality manager, angered the jury when he testified that the number of injuries, 700 and counting, was insufficient to cause the company to even evaluate its practices. And he argued that McDonald's had, quote unquote, more pressing things to be concerned about. So the jury got a little angry, but they found McDonald's was 80% at fault and Ms. Stella Liebig was 20% at fault, even though she was simply trying to take off the cover of her coffee. They awarded $200,000 in compensatory damages and reduced it by 20% for her negligence down to $160,000, but they awarded her $2.7 million in punitive damages, which was simply 2 days' worth of profits on coffee. The judge immediately reduced the punitive damages the same time the jury came back to $480,000, so the total verdict was $640,000. They appealed it, and later on they settled it for an undisclosed amount. Undisclosed, but I happen to know the amount, and I want to tell you it is a pittance. So although frivolous lawsuits continue to be a drain on the insurance industry and the American economy, as we proceed in this webinar, I want to leave you, because I think it's very important that we try to think like trial lawyers when we're recognizing and investigating third-party liability. Even a good investigator, even someone who has been investigating for years and a claims handler with experience, is not going to be as effective in subrogating as somebody who has the ability to remove sort of that myopia that some of us in our industry, I guess, as a whole, carries with us. So investigation, we're going to talk a little bit about the why. Why do we investigate? Well, it's perhaps the only chance we're going to have at some evidence. I can't tell you the number of files I get 2, 3, 4, 6 months, a year, 2 years after the accident where there's been no investigation. Slip and falls are an anathema this time of year for us in the northern states. Snow, ice. You've already had the benefit of a premises liability webinar. I think it was one of the first ones you had. Richard Womble gave you. No doubt you went over the natural accumulation rule. We're going to touch on some premises a little later on here. But the fact is that unless you have documentation as to the condition immediately after a loss, you're going to have very little chance at premises liability slip and fall cases, because it's our burden to prove that there was a dangerous condition, unreasonably dangerous, and that the defendant had notice of it and didn't act as the reasonably prudent person would have. So investigation is important for that reason. It's also important to catch witnesses when memories are fresh. In workers' compensation, this is perhaps one of the paramount premises I want to leave you with, because we all know what happens when someone is injured. When a worker is injured and we don't get to witnesses quickly, we don't do our investigation quickly, the wheels of the large corporations grind slowly, but they grind exceedingly fine. And I can guarantee you that over the course of the week following the injury, the employer is already circling the wagons because they are confused. As far as they know, somebody can sue them and the company can be forced into bankruptcy and they all can lose their jobs. So what they immediately try to do is circle the wagons and blame the injured worker. And this can result, and I've seen everything from fabricated evidence to employee meetings in which they all sort of agree to say that he was intoxicated or had been, smoking marijuana, or any one of a number of things, down to simply, well, he's always been a careless employee, more subjective things which can't be cross-examined against too easily, and he had no business there, and we've warned him many times not to do that. These are things that kill subrogation potential, but if we investigate and investigate promptly, we catch these witnesses and we get them when their stories are fresh and before they've had a chance to be indoctrinated by employers who don't understand that what we are trying to do is actually help them, which is another reason for the investigation, because we can explain the process to the insured. We can explain to them that what we're about to do is not only going to help one of their employees, but it's going to help them, because it will help with their experience mod, and it will help with their premiums in years to come. And there's no way that they can possibly be sued if you explain the law and the exclusive remedy provisions under Wisconsin law. And of course, there's a couple exceptions. The wacky state to the south and to the west have some provisions which allow an insured to be brought in for contribution. But in those situations, there are many abilities to simply limit their potential liability to the amount of the lien, which means waiving the lien. So having said all that, it's important to explain this process to the insured, to the employer. It also may be the only chance to recognize the issues that are involved. When you investigate promptly, you may come across issues which may kill subrogation potential. But wouldn't you rather find those out the day after a loss as opposed to after 6 days or 6 months of litigation? The time and energy spent on a thorough investigation, I've always said, is inversely proportionate to the cost of subrogating. The more you do up front, the more thorough you are, the easier it is for us to litigate a subrogation claim and effect a recovery. You also identify roadblocks such as indemnity clauses in construction contracts, waiver of subrogation, agreements, facts which could literally kill subrogation potential. And your investigation is a walkthrough of the third-party lawsuit, so you're going to have a great idea as to what's happening. And so as we litigate a case, if we're reporting to you, you have the ability, I apologize for that, you have the ability to thoroughly provide feedback and assistance as we subrogate that claim. In addition, it's on-the-job training for subrogation and claims personnel. There's no better way to understand third-party liability law, tort law, than investigating a claim with the assistance and feedback of subrogation counsel. You can lock witnesses into positions in testimony, and one of the tricks I always use is when you take a recorded statement of a witness, and it's favorable, and that's an important part, and you transcribe it onto paper. If you then take it back to that witness and have them sign it, there is a cognitive phenomenon that occurs when a witness signs something. And then when they sign that and later on they are talked to by the employer, or they forget, or they're somehow they are gotten to by the other side, you can then show them that statement at a deposition and ask them if they signed it and read it and approved it. And it has a tremendous effect on keeping them on target and on task in terms of what their testimony is going to be. In addition, investigation provides the opportunity to give notice to government entaties, towns, cities, states, and the federal government who have short fuses on third-party liability. We'll talk about that in a little while as well. So what is it that we talk about when we're talking about investigation into subrogation potential? Well, we want to look into the facts and details surrounding the injury or the death. This is actually when you conduct an investigation, you have statements, you have perhaps an expert who has looked at it and given you a preliminary report or talked to you about what he's found. You have photographs. You have actually obtained and retained evidence, and we're going to get into spoliation here in a moment. But you now have created a valuable commodity that can be bartered to your advantage. And what I mean by that is, and this is especially true in workers' compensation, you can take that packet of information because the worker often doesn't hire an attorney until sometime after a loss. I mean, it's not uncommon 6 months after a loss to have a claimant out there who's still trying to decide whether to go to the TV guide and hire an attorney. This product that you've created, your investigation, can be bartered because the plaintiff's attorney wants that information. He's at a disadvantage getting into the case late. And if I can give him your work product, then he might agree to stipulate with us. And this is especially true in states that are not as favorable as Wisconsin with regard to workers' compensation subrogation. He may try and get that documentation from us by issuing a subpoena or having the judge order that we turn over our investigation. But this is where work product privilege comes into play, because as long as somewhere in your file you've indicated that you're investigating for subrogation purposes, it becomes work product which is privileged and exempt from discovery. So the judge can't order you to turn that over as long as it's properly documented. This gives us the chance also to get information from the employee before he is represented. And sometimes they're a little more candid before they're tutored and woodshedded by the plaintiff's attorney, and that gives us a real good opportunity to decide whether or not the case has merit and it's something we want to prosecute. It's also a chance to bring extraterritorial issues into play, and this is specifically with regard to work comp, but you now have an ability to investigate not only the facts, remember I said earlier the law as well. If we have an injury which occurs in Illinois, but Wisconsin we have a Wisconsin employer, we may have an opportunity to pay either Illinois or Wisconsin benefits, or Minnesota or Wisconsin benefits, or Iowa or Illinois benefits. And it might help to check on the law, and you can do that by checking with us. You can look at the work comp book that we've written, or you can look online on our website. We have a chart that details work comp subrogation laws in all 50 states. You want to probably apply the law or the benefits, pay benefits under the state with the most favorable subrogation law, because even if the suit's filed in Illinois, it is possible to apply Wisconsin law to that Illinois third-party case, not with regard to contribution, but with regard to distribution of a third-party recovery, and vice versa. So extraterritorial issues come into play. It also gives us the opportunity to represent the plaintiff's interests. And what do I mean by that? It's something we call networking, and it means that if I can somehow place that injured employee, that insured, with an attorney who will zealously and aggressively represent his interests or her interests, and in exchange get a stipulation whereby they are going to protect our subrogation interests and stipulate to them without our having to be intimately involved, without having to pay for expenses, maybe even getting out from having to pay attorney's fees, we've won. All we now have to do is hope that they get a plaintiff's verdict and we get our money back. So there's some networking opportunities there as well. It's also an opportunity to uncover third parties and sources of recovery, and that's what the rest of the webinar is about. Now, the investigation, the how, well, this consists of a lot of different tools that we have and that you use. Some of my clients, the claims handlers, do it all. They're utility infielders. They play the outfield. They're pitchers. They're catchers, and they also are the bat boys. They adjust the claim. They handle the reporting on that claim to management. They also handle subrogation and put on the subrogation hat. They do all of the investigation. They hire the experts. They coordinate everything. So they're basically a jack of all trades. And other clients I have SIU units. They have special investigators. They have dedicated central recovery units. And so the tasks are handed off. And there's pros and cons to both, which we won't need to get into. But understanding the how is extremely important. When investigating any claim, a fire loss, a machine, expensive machine that one of your insureds burns up, a vehicle left with a repair shop burns up or is stolen and there's a bailment case, a large work comp case, auto, whatever. No matter what it is, there's the investigation of that claim should be completed with one simple philosophy in mind. And I refer to, and some of you have heard this in previous webinars, but the allegory, the parable of the pebbles. And that has to do with the story of the two nomads in the Middle East who were traveling through the desert with their camels and their saddlebags, and they stopped for the evening, and they took off their saddlebags, put up their tents, and were just about to retire for the evening when suddenly a great light shined from the sky, from the heavens, and a loud voice boomed out. And they came out and fell to their knees, trembling at the sight of this awesome deity who was now going to reveal something to them. And he said, I want you to take your saddlebags and fill them with pebbles. And then tomorrow, after your day's journey, when you break for camp, I want you to open those saddlebags, and you will be both glad and sad. And the nomads looked at one another, and the light went away, and the voice disappeared, and everything returned to normal, and they were instantly a little annoyed because they had expected some great revelation on happiness or success in life or some secret to life itself, and instead they got this stupid task assigned to them. So a little bit peeved, they put a few pebbles in their saddlebags, threw them to the side, and then went to bed. Next day, as you might expect, they got up, they traveled the day's journey, and then when they broke for camp the next day, they pulled off their saddlebags and looked inside, and what they found were each of those few pebbles they put in there had instantly turned to brilliant, perfect diamonds. And at once they realized that they were both glad and sad. They were glad that they had taken the time to put a few pebbles into their saddlebags, but they were sad and depressed that they hadn't stuffed those saddlebags full of pebbles. And that's how investigation of third-party cases should be approached, no matter what line of insurance you're dealing with, because you do not know when you start your investigation what insignificant portion of what you uncover in your investigation may be the linchpin that saves the entire case. When you're investigating, we're talking about statements, recorded statements. We're talking about photographs, preserving evidence, observing witnesses, taking measurements, obtaining documents, engaging experts, giving proper notice. You're going to come to some conclusions, write a summary, make some recommendations, and then perhaps even engage subrogation counsel. Excuse me one sec, it's the voice. Okay, thank you. These are the tools that we are going to have to help us investigate third-party liability. And one of the things that we have to recognize is the potential of spoliation and how we have to avoid potential spoliation, not only because it could affect our subrogation recovery, but also because the things that we produce are and may be depended on by our employee, our insured, and the trial lawyer somewhere down the road who eventually represents one of them. Matthiesen, Wickert Lehrer wrote an amicus brief in a case which came out by the U.S. Supreme Court in 2009 called American Family Insurance Company versus Gelke. Spoliation is a mysterious, amorphous legal concept. Everyone talks about it. You can go out to the site of a fire scene with an expert, and you can pull out every possible piece of evidence that you can think of and store them all in a huge warehouse and keep it under lock and key and provide everyone with notice, allow for inspections, non-destructive, then later destructive, and you will still have claims of spoliation, which sort of spooks all of us into fearing this albatross known as spoliation. But in the American Family Insurance Company versus Gelke case, for the first time in Wisconsin, we were given some clear instructions as to what our obligations are as an insurance company investigating a loss. In the year 2000, there was a fire which destroyed a home that was owned by a guy named David Ronaldson. As a result of this fire, American Family incurred about $165,000 in costs for rebuilding the home and for contents. They retained 2 cause and origin experts to investigate the fire. They went out and did their thing. They investigated, they inspected, they took photographs, and they were able to determine that the cause of the fire was caused by faulty roof work done by a contractor called Gulke Brothers Roofing and Siding. Now, American Family immediately notified Gulke Brothers by regular mail of the loss through its principals, its owners, David Gulke, Charles Gulke, and Joseph Gulke. David, Charles, and Joe were brothers, and they owned Gulke Brothers, and they provided their insurer with actual notice. And they were all afforded the opportunity to come and inspect the fire scene. But neither the Gulke Brothers nor its insurer inspected the site or requested that anything be preserved. So 2 months after the fire, American Family gave Mr. Ronaldson, the owner of the house, the authority to rebuild it. He wanted to rebuild his home. Now, American Family ultimately pursued subrogation, and the defendants raised a spoliation defense. They argued, hey, American Family had a duty to preserve significant amounts of physical evidence. Remember, no matter how much you preserve, the defendants, and it's their job, is going to claim that there was something else that you didn't preserve, something else that was significant to the defense of their case that you didn't put aside, and as a result, the judge should dismiss the case. In this case, the defendants argued that American Family had a duty to preserve certain physical evidence, which they didn't, and therefore asked that the case be dismissed. Although American Family's experts, they documented the scene with photographs, the trial court found that American Family failed to adequately preserve certain evidence, and they dismissed the case entirely based on spoliation. They said American Family owed a duty to preserve much of the physical debris from the fire despite giving the defendants notice and an opportunity to inspect. American Family appealed that case, and the Court of Appeals immediately certified the case to the Wisconsin Supreme Court. The National Association of Subrogation Professionals asked us to write an amicus brief, which we did, and we made several suggestions in that brief, and to our pleasure, the Supreme Court listened. But under pre-existing Wisconsin law before this case, dismissal as a sanction for the destruction of evidence required a finding of egregious conduct, which in this context consisted of a conscious attempt to affect the outcome of litigation or a flagrant, knowing disregard of the judicial process. Well, clearly that hadn't happened in this case. They gave notice. Gulke Brothers, their insurer, they didn't heed that notice. They didn't do anything. So American Family was justified. If they thought they had enough evidence to prosecute their subrogation claim, why should they be punished for not doing the other party's job of investigating the loss and conducting an investigation? Well, we wrote the brief, and in the summer of 2009, after a long wait, the Wisconsin Supreme Court finally reached its decision, and they sided with American Family and with our amicus brief on all issues. The court said that the duty to preserve evidence is discharged once the party in possession, that's us, has given reasonable notice of a possible claim, the basis for that claim, the existence of evidence relevant to the claim, and a reasonable opportunity for inspection of the evidence. That's it. The court said that a trial court may use its discretion guided by the totality of circumstances to judge the sufficiency of the content of notice. So this becomes a common sense situation where the judges now look at certain factors to determine if we gave adequate notice and committed the tort of spoliation. Those factors include the length of time evidence can be preserved, the ownership of the evidence. If it's not ours, we can't really hold it. It's not our evidence. If the insured owns it and they want to destroy it, or they want to restore it, or they want to sell it, there's nothing legally we can do. They have a duty to cooperate, but they don't have a duty to turn over property to us. So there are situations where it may require our purchasing that property, or getting a court order, or getting an injunction. But that's another. The factor, again, is the ownership of the evidence. The other factors are prejudice posed to possible adversaries by destruction of the evidence, the form of the notice, the sophistication of the parties. In this case, an insurance company was on the other side. They ought to know better. And lastly, the ability of the party in possession to bear the burden and expense of preserving the evidence. And when you have a house and people displaced, living in a motel somewhere, I think those factors weigh heavily in favor of get in, get out, fix the house, now we have our evidence. So the court also said that notice to potential defendants via first class is appropriate. The legislature, they said, has long recognized, and this is a quote now from the case, that first-class mail service is an efficient mechanism that is reasonably calculated to provide actual notice of possible or pending litigation. Notice of mail is usually considered complete upon mailing, not proof of receipt. So if you pop it in the mail and preserve evidence of that, the presumption is that they received the notice. And this presumption cannot be overcome without a denial of receipt, and mere non-remembering whether I received it will not be sufficient. So investigation, the how, these are some examples. A quick, with regard to photographs, you know, we live in a remarkable age of technology. The fact that I am here sitting at my desk and you are there in Stevens Point and we are looking at the same screen and I'm able to give a presentation to you without battling traffic or weather, and I'm able to get back to work immediately when I'm done, it's a miracle of technology. With regard to photographs, it's the same thing. We have the ability to take digital photographs now by the thousands. And if and when you're out taking photographs, I tell people take a zillion photographs. The more photographs you have, the better, because some angles are better than others, and you won't know which is which until a particular issue comes up in a case, and it normally won't come up until litigation. I always recommend taking flash photography. And the reason for that is flash photography sometimes reveals things that normal photography, even in adequate daylight, doesn't reveal. A case in point is I had a case involving a very expensive home in New Orleans owned by the former owner of the New Orleans Saints, John Meekum. And it burned to the ground back in 1988. I think he sold the team back in 86 or something, but he had a very nice house. And Hartford sent out their in-house SIU investigator, and there were still some things standing, and one of the things standing was in the foyer. There was a large mirror, floor-to-ceiling mirror, and they were 12-foot ceilings, and it was covered in soot. And the investigators, the arson investigators, the sheriff, the cause and origin folks were all out there, and they took photographs of everything. But our Hartford investigator took, even though it wasn't necessary because there was plenty of sunlight, took a flash photograph of that mirror and was able to, when he developed the film at that time, it was regular chemical film, was able to see that someone had written with their finger in it, "Sorry, Mom." And it was through that photograph that we went and got the stepson and determined that the fire had actually been arson. And so they called me after that and told me that they had discovered that using that little tip of using flash photography. Of course, there are other cases where we're trying to show darkness of a hallway. I had one last month down in Illinois where there was a slip and fall in a restaurant on a carpet that continually rolled up, and it was almost pitch black in the hallway. So I sent an investigator down, and he took a bunch of photographs using flash photography and came back and said, "Here's your hallway." Well, in the photographs, the hallway was completely lit up. It looked like it was high noon. And I said, "Well, my God, that's not dark at all." He said, "Oh, but it is dark. It just was lit up because of the flash." So you have to know how to sort of turn off your flash when appropriate. So that's the how. But with regard to third-party liability, the tort law school class portion of this webinar, which will be the last half we go over here, recognizing liability of a third-party tortfeasor is really the key. If you don't recognize it, as we said early on, nothing will happen. And we can talk about general negligence, which is common law, medical malpractice, premises liability, products liability. When we talk about general negligence, a concept I always try to impress upon people is this. You don't have to violate a statute to be negligent. If you're speeding, you're violating a statute. You're negligent, and perhaps negligent per se, meaning you're automatically at fault. You're automatically negligent simply because you were in violation of a statute. If you run a red light, you are automatically negligent because you have violated a state statute which says you can't run red lights. But most negligence claims do not involve the violation of a statute. They involve what's known as common law, which is simply man-made case law that comes down to us over what comes to us actually from England, from common law in England, but it's basically court after court after court has honed and polished and condensed duties and breaches of duties into a semblance of maxims. So if you are standing in an elevator, there is no statute which says if you're in a crowded elevator, you can't spin around with your hand extended out and your closed fist. Because if you do that, chances are pretty good you're going to hit somebody. And you could probably see who you're going to hit as you're spinning around. If you do that, if you spin around in a closed elevator with your eyes closed, you are now not intentionally going to hit anybody because you can't see anything, but you know as a reasonably prudent person that you probably are going to hit somebody, and that is common law negligence. So these four concepts really play into understanding third-party liability. Now, in the workers' compensation context, as we've discussed, who can be sued becomes a big issue. A co-employee. Now, Wisconsin has some rather interesting rules with regard to when and whether a co-employee can be sued. There was a period of time where a principal of a business or a manager or somebody with the apparent authority of management, if they came down to the factory floor and assisted in something and actually put on a worker hat, where they could be held liable. But that law is no more. Generally, employees are immune from suit in almost every state unless they conduct some action which is tantamount to an intentional act. In some states, it's lowered to a gross negligence threshold, but generally, co-employees are immune in work comp situations. We talked about UM, carriers, doctors, and again, the exclusive remedy rule, which is something we have to rehearse preaching to our employers in work comp situations, that generally the employer is immune from suit. There was a case which came out last year in the Missouri Court of Appeals, Robinson versus Hawker, and it was in our newsletters, which basically said all co-employees can be sued. They're fair game. Now, the Missouri legislature is in the process of trying to pass some laws to repeal that right now so that that won't be the case. Now, automobile accidents, they're the most common third-party lawsuit in America. It's common sense that you want to get a police report, but understand a couple of things. That police report is not evidence. You can introduce it as an official record, but in many cases, any hearsay contained within that police report can still be kept out of evidence. It is important oftentimes to contact a police officer, and when you do that, it's good to get him, it's nice to meet with him in person, give him a copy of the report, let him review it, and say, can you tell me a little bit about this? His opinion in many jurisdictions will play a role, but it has to be an informed opinion, and it has to be drawn from his particular recollection of the facts, not simply the report. But, of course, getting a police report gives you the facts. It tells you who's involved, what the officer thinks happened. Oftentimes it gives you excited utterances, declarations against interest of parties to the lawsuit that are admissible, and you get some idea as to what you're dealing with. Is it a failure to maintain proper control of a vehicle, failure to maintain a proper lookout, failure to yield, improper turn, deviation from the lane? We have a book. And those of you who know me know that trust me, we don't make any money on these books, and we spend thousands of hours writing them, and the publisher, I forget what we get, like $19 a book. So we would go broke if we made a living out of writing books. But the reason I mention this is we have a book that's coming out that Juris Publishing out of New York is really hyping, and apparently from the feedback they're getting, it's pretty much in demand, called automobile insurance subrogation in all 50 states. And it's an anthology of law, history of automobile insurance nationally, different subjects, arbitration. But it also contains a chapter on each state. And on each state, there's some 50 pages dealing with subrogation rights generally, what automobile insurance coverage is required, what no-fault laws there are, how those no-fault laws work, if there are any, med-pay subrogation, PIP subrogation, collision and property subrogation. Can you recover? If so, can you recover loss of use? What's the standard? Is it cost of repair? Is it reasonable market value before and after? The made whole doctrine. What happens if it's uninsured, underinsured motorist subrogation, pulling driver's licenses, when you can, when you can't, what you have to do it. What if the insured is released, or the tortfeasor is released by the insured? Can you still subrogate? Common fund doctrine, economic loss doctrine, collateral source rules, seatbelt defense. See, we're talking about automobile accidents. Is it a defense for if your insured was injured but wasn't wearing a seatbelt? Well, in Wisconsin, we have a seatbelt defense. It's statutory. You can get up to 15% negligence imputed to the plaintiff as a result of not wearing a seatbelt. But every state is different. And in many states, there is no seatbelt defense. And in other states, there's just the common, we're going to let the jury decide if they think not wearing a seatbelt contributed to the exacerbation of the injury, then we'll allow them to apportion some negligence as a result. Bailment law, rental cars, loaner vehicles, and test drivers. It's my understanding that you just had a discussion from some gentlemen on automobile dealership operations. Matthiesen, Wickert Lehrer represents General Motors and Motors Insurance Company and all of the GM dealerships in the country with regard to property loss. And this includes everything from fires to vandalism to as we've talked about, I think we did, yeah, we've talked about on the 21st on Act of God, the Subrogating Against God webinar. So there are a lot of claims that arise in those situations, but when and where can is the coverage or the insurance policy for the dealership, its garage keeper's policy, its fleet policy, when is that primary versus the personal automobile policy of the gentleman or woman who loans or rents the vehicle or is loaned the vehicle or is test driving when the accident occurs? So dram shop liability, guest statutes, the family purpose doctrine. Do you realize that a lot of states still have a law which says that if the family vehicle is being driven by any member of the family for a family purpose, that the head of the household, and it could be a couple, the parents can be responsible vicariously for the acts of the person driving the vehicle. Now that's remarkable vicarious liability opportunity there that sometimes we don't take the time to recognize. A guest statute, whether or not there is immunity for a driver from a lawsuit by a passenger in a vehicle. Dram shop liability. Almost every state has taken some stance on whether or not the provider of alcohol can be responsible when the driver of a vehicle who is perhaps underinsured or uninsured causes damages, injury, or death. Most states, the majority of states, hold that a provider of alcohol is responsible in one of two situations. Number one, when it provides alcohol to a minor, like Wisconsin, and number two, when it provides alcohol to a person who is reasonably appears to be intoxicated already. In those two instances, the majority of states allow dram shop liability, but most states, I think all but 4 or 5, say that the injured person, the intoxicated plaintiff, can't be the one suing because he's the one who obviously imbibed. So regardless of how you feel about dram shop liability, Wisconsin, of course, has such a large tavern lobby that we don't have dram shop liability as such. And I don't think we will in the foreseeable future, but many other states do. So especially if you're adjusting here in Wisconsin and you have an Iowa loss, know that that liability is out there. So these are some areas to look at in terms of general negligence. Some examples: if an employee slows for traffic and the third party rear ends our vehicle, obviously we have the failure to maintain a proper lookout. Those are easy. You have the defendant stops for traffic and our insured or an employee does the rear ending. Well, is there subrogation potential here? And I'm going to stop you and ask you to put on your McDonald's hot coffee hat for a second. Because these are cases that you would automatically say, well, of course there's no negligence here. Our insured did the rear ending. And how in the world can Gary Wickert suggest that there is? Well, we've had a lot of successful recoveries in cases where the insured or the injured employee actually did the rear ending. I'll give you one example, and it happened in Texas about 10 years ago. And a gentleman was traveling on a state highway, 55 miles per hour, and he was traveling at about the posted speed limit early in the morning, heading to work before the daylight savings. It was dark. There were no street lights. He was out in the country, and little did he know, but ahead of him, in his lane of traffic, a giant cement truck had pulled onto the highway and had traveled almost 400 feet. That's almost a quarter of a mile. Well, no, it's not 400 feet, not quite a quarter mile, but he had traveled a pretty long distance and was still in second gear, discovery later revealed. And the 2.5-inch diameter red taillights in the back of the truck were both covered with dried cement and weren't visible. So here we had a truck going about 15, 18 miles an hour and a vehicle going 55. It collides with the rear end of this truck. There were skid marks right before the collision. There was some contributory negligence imputed to our driver, but he had some horrific injuries, including a hip displacement, broken legs, and some complications from those injuries. And we were able to make a recovery by showing that they had not washed this truck in months. And as a result, it was a hazard on the road. So again, take off the claims hat, put on your plaintiff's attorney hat, and think about those sort of things. You also have situations where, okay, there's a horse in the road or a cow in the road, and somebody comes to a complete stop and gets out of their car, no flashers on, and they're rear-ended. There's always going to be contributory negligence if you run into something ahead of you. We're handling a case right now in Iowa where a state trooper was crossing at dusk a double railroad crossing, and on the second track was a train that had completely stopped, and what was across the roadway at this railroad crossing was a flatbed rail car that was extremely low to the ground. The second track was lower elevation than the first track, so this flatbed railroad car could hardly be seen. About 10 minutes prior to this accident, a woman had just barely avoided the collision by driving off the road and into the ditch. And in fact, her car was there, and she witnessed this accident. So it's hard to prosecute a subrogation case successfully when you have someone that drives into a train the size of an elephant. But the fact is, we have got a settlement offer in that case and are going to push for more because the facts really do help us in this case. There were no lights, there was no warnings, despite the fact that there was an engineer walking on the track who had seen the first near miss, and yet no flares or anything were put out. So again, put on your plaintiff's hat and be a little creative. When the defendant pulls out from a stop sign and strikes an employee's vehicle, you know, these are common scenarios that we have to evaluate. Who had the right of way? Is there subrogation potential? Was there a failure to yield? If an employee pulls out from a stop sign and strikes the adverse vehicle, who had the right of way? Is there subrogation potential in that case? Was there excess of speed? Were there lights on? Were there turn signals on? What we tend to do in these cases is simply rely on the police report and our insured statement. We figure, number one, the adverse isn't going to give us anything positive, but we don't take the extra steps. Some of the more successful swearing match intersection collisions we prosecuted involve us walking across the street to a business and obtaining security camera film. Or in one case, I was able to track down gas station receipts from the time of the accident, and you know, the computerized credit card machines tell us exactly who's pumping when. I was able to get a number, a credit card number, get the name of the customer who was there, tracked him down, and sure enough, he said, yeah, I was pumping my gas. I heard the sound of squealing tires. I looked. I saw the red car braking and turning sideways, colliding with the blue car. And I said, at the time of that collision, what was the traffic light for the red car? And he said it was green. That guy was my star witness in the case, and we made a recovery all because we were able to track him down. So again, it's the investment concept here that really matters. With automobile accidents, we want to get our police report, talk to the officer. We want to get names and statements of witnesses, as I said, photograph the vehicle damages, skid marks, debris, signs, signals, anything, because nobody may be out there at that accident scene until a couple of seasons later. And if you've taken photographs of key debris or gouges in the pavement or skid marks or disturbances of the gravel in the shoulder of the road, those things are very key. I get a lot of photographs from auto cases that show, well, this is the view looking north, this is the view looking south, and this is our opinion. Again, photographs are cheap. Take a ton and use common sense. One of the arguments I use in trying cases, let's say you have two folks, your insured is at a red light at an intersection, a red stoplight. The light turns green, and he proceeds through and is immediately T-boned by the defendant, who claims he had the green light. Now, if you talk to a jury in common sense terms and say, imagine, put yourself in the position of my client, your insured, the gentleman sitting at the red light. What are the chances that he's going to decide, well, this red light is a little too long, I'm going to gun it and go through the intersection on a red light? It's almost nil. I mean, we've all done it at one point or another, but you know, usually at 4 in the morning or something. The fact is, the odds are that what happened here, even though we have no witnesses and two different statements, the odds are that the defendant was coming up to an amber light and tried to run the light. As it was turning red, it turned green, our insured proceeded, and there was a collision. Now, this doesn't alleviate our insured of his statutory obligation to check both ways and make sure that the intersection is clear when he proceeds on a green light, but it does put, and did put in that case, the onus on the jury to feel that, hey, I think the guy who's at fault here is the guy who's trying to race through this red light, not the guy who's patiently waiting at the red light and then proceeds cautiously, or perhaps not so cautiously, at the green light. So use common sense. Weather, trip logs, vehicle inspections. Do you realize that companies, especially trucking companies now, have computerized records of trip logs? They have GPS in the vehicle. Many of these companies are placing video cams in their vehicles. There are a number of vehicles out there that have computers in them placed in certain vehicles so as to analyze new vehicles that are put on the market, and these things are available from the manufacturer. You can break into them and get the codes out of them and determine exactly what happened prior to impact. Trip logs for trucking companies, which are often fabricated. I'm still shocked every time I try a trucking case and learn exactly how some of these logs are recreated. They're recreated, you know, at the end of every month, where they just kind of, okay, I worked 8 hours here, 8 here, 8 here, 8 here, and what they don't put down is that they had 16 hours in one day of driving, even though the law prohibits that. Use of experts. In automobile cases, you may have an expert that you want to use with regard to accident reconstruction is a common expert that would be used in an auto case. Again, unless you have a case like our single car accident and you want to look at crashworthiness, or there's an unexplained etiology, an unexplained, there's no explanation for how a car suddenly swerved to the left, went across the median, and struck someone head on. You may want to look at that vehicle to find out if there's any sort of tire failure, in which case you need a tire expert. Is there some sort of steering problem or a mechanical issue with the vehicle that somehow affected its operation and the ability to maintain control? Those experts we can help you find. If you need an expert, be it an automobile case or a med mal case or a product liability case, we have collected a database, as most of you know, over the last 20-plus years of tens of thousands of experts located throughout the country based on geography, based on discipline. Are they a mechanical engineer, electrical engineer, a civil engineer, and exactly what is their price point? Because on the small cases, we can't afford to hire the expensive experts, and on the high-dollar cases, we can't afford to hire the cheap experts. And it's as simple as that. So there has to be some cost-benefit analysis used. I'll talk a little bit about medical malpractice because we want to be able to recognize this as well. We do have a program whereby we have doctors who will look at potential cases of medical malpractice. I mean, there'll be medical devices left in the body. It could be a sponge or a, who knows. We could have infections, which are extremely difficult cases. It could involve simply a lack of judgment. Medical malpractice cases are increasingly difficult, not only because of tort reform, but because of degrees of standard of care, which have been developed by case law and common law throughout the country. You can have a doctor. I had a case the other day. A doctor actually nicked and severed the nerve sac in the spinal column while conducting a double laminectomy. And the doctor that we hired, who has been very good for us, opined that it isn't necessarily negligent, that there are certain, as long as he does what's expected in the industry, doctors are not perfect. He said it's like the game of operation, and it's a rather simplistic analogy, but sometimes you can't help but touching the side and the buzzer goes off and the nose lights up, and in his opinion, sometimes juries aren't going to find a mistake in judgment. You're not responsible for a mistake in judgment. You're not responsible for reasonably foreseen complications, which is why you sign the informed consent. You're only responsible if you do not uphold the standard of care in that particular geography. And most states require a doctor in the locale where the accident happens. And I can tell you that in the state of Idaho, we've had some rather good medical malpractice cases there, but I need a Boise doctor to testify. And because we're in a small state, population-wise, in a small city, population and medically, in the medical community, it's very difficult to find a doctor to testify against another doctor, but that's what you need. A couple examples of medical malpractice. I'll go through these quickly. An employer injures the left shoulder, back, hip, and head after a slip and fall during the course and scope of employment, undergoes a fusion surgery of several vertebrae, and thereafter has trouble swallowing. There was some negligence perhaps with the scoping or the feeding tube. 2 weeks later, suffers shortness of breath and diagnosed with pneumonia and respiratory failure. And upon further examination, it discovers that a surgical screw is protruded through the back wall of the employee's esophagus, resulting in an infection. So the question, was this a reasonably foreseeable complication or medical malpractice? Those are questions that can only be answered by a doctor. And so what we do is we summarize the medical records so we don't take up too much of the doctor's billing time. We give him the summarized records. He gives us an opinion. And if we get a thumbs up, we then engage a doctor with that opinion in the locale where the accident happened, and we proceed. Medical malpractice cases are not easy, and so we often recommend trying to get the plaintiff to engage a doctor, but it's easier to do that if we already have an opinion that medical negligence occurred, and then all they have to do is concur with that opinion. Now, you've had some discussions already on premises liability, and you've been told about the 3 types of users: trespassers, licensees and invitees. You may or may not have had discussions on bailment. Our upcoming, the book that I mentioned to you talks about something that I think you need to keep in mind when investigating and attempting to recognize subrogation, and that's the concept of bailment. Bailment is the subrogation professional's friend, because if, let's say, you provide a vehicle, your insured's vehicle goes into a repair shop, and the vehicle is not returned, or it's returned in a damaged condition, you have a cause of action for bailment. That is negligence on the part of the shop owner, the bailee, for damage to the vehicle. But the reason it's our friend is because bailment carries with it a presumption in most states. That presumption is, if we prove we gave the vehicle to the dealership dealership did not give the vehicle back, then the burden in about half the states actually shifts. And it is now the dealership that has to prove it was not negligent. If the car was stolen, it's not simply good enough to say, hey, the car was stolen. Some thief came and stole your car. He has to also prove that he took every precaution, the dealership took every precaution to protect that vehicle. And while it's only tangentially related to premises liability, I know you've gotten into this quite thoroughly in your other seminar on premises liability. But there's a couple things that I'd like to talk about that deal specifically with investigation of premises liability. And again, we're talking about the pebbles, the saddlebags and the pebbles. When you have slip and fall in construction situations or hazards on construction sites, it's more important than ever to document the condition and document it soon. And by that, I mean photographs, measurements, getting witnesses. A construction site is a live operation. It's constantly in motion, and it's constantly changing. It's dynamic. It's not like an insured's home where, you know, something happens and you can just tell them to hold everything. The construction is going to go on, so it's important to get out there quickly. Something that a lot of investigators forget is what time did the accident occur. I've had a lot of cases over the years where accidents occurred at 4:35 p.m. The investigator goes out the next day at 9:00 a.m., takes a bunch of photographs, determines that the injured subcontractor who stepped into the elevator shaft, while the elevator shaft wasn't marked, it was clearly and openly obvious. And one of the questions I've cross-examined them with are, well, what time did you go out there, sir? I was out there at 9:12 a.m. until about 10:30 a.m. I see. And what latitude are you at? Well, I don't understand the question. Well, isn't this in, Wisconsin? Yes, it is. And was this in December? Yes, it was. Well, as I understand it, in December, about 9, 10 in the morning, it's pretty light outside. Oh, it was light. It was sunny, and there was reflection off of the snow. But the accident happened at 4:35. Yes, sir. Well, isn't it dark at 4:35 in the middle of Wisconsin? I don't know. And suddenly those Wisconsin jurors will know, oh, yeah, this is the time of year I hate, where I feel like it's time to go to bed at 5 o'clock in the afternoon. So little things like that. This is the common sense approach that is so important when you're investigating. It's not rocket science, but it does take some forethought, and it does take removing that claims hat again and putting on that trial lawyer's hat. A sketch of the area is critical. We had an investigator here at our firm who would go out, and one of the things he would do is draw a diagram. He had some graphic design experience. He would draw a diagram of the facility with X's showing where everything was. It's a key tactic used in depositions, but if we have a sketch, we have a much better understanding of the entire building and how everything relates, every area relates to everything else. Warning signs. I'll tell you, this is a trick that I've used when I go out and investigate, and I did this at an airport, a small airport. This was in Texas. And there was a slip and fall involving water outside of a restroom, and it involved a serious injury. Some slip and falls are worse than others, but this one was pretty bad and involved some pre-existing conditions. But there was the argument that, well, there were some warning signs out. No one saw the warning signs, and I asked for the contractor who was responsible for the maintenance of the airport to tell me what the warning signs looked like. They described them, and I walked over to a nearby maintenance closet and opened it up and found some warning water, whatever it said, cautions, wet surface, but they were completely different than the one they described. So I took pictures of those, and then I went back and I asked if they could produce the signs that they described. So it's little things like that that really can make or break a case. You have no idea how significant the investigation portion, the portion that may be going on without attorneys involved in at all, is to the outcome of a case. And timing, of course, is everything. In slip and falls, you've heard this earlier. How long was it there? Notice, prior complaints, other conditions, and these are again key issues when you're dealing with premises liability. Now I want to give you just a quick example. An employee is making a delivery to a private residence in the course and scope of employment. This would be work comp. Slips and falls on the ice outside of a home. Stairs might not be up to code. There might be uneven. But the fact is that winter in Wisconsin is long and hard, and right about now we're all going to be in agreement on that. The frequent presence of snow makes it more dangerous than it needs to be. But this is a fact of life here. Slip and fall cases in Houston, Texas, and I've tried those, are a different matter. But the presence of snow and ice here tends to make people slip and fall, sometimes with serious injuries, sometimes something as simple as a slippery floor, a loose sidewalk, heating grate, or a poorly repaired step can result in these injuries. But to determine liability for slip and falls on snow and ice, and please forgive me if this is a repeat from something in the premises webinar, but it's significant. We follow something called the natural accumulation of snow and ice rule. In order for there to be liability for a fall on snow or ice, the snow or ice that you must fall on must be an unnatural accumulation of snow or ice. This means that if you fall on snow or ice in front of a storefront that has failed to remove snow or ice, you may not be able to recover except for extenuating circumstances. And it always is going to be the jury's call, but they're going to be instructed on this. The failure to remove the natural accumulation of snow or ice is not usually a basis for negligence. However, if it's a natural accumulation of snow or ice, no liability, but the dividing line between what's considered natural and what's considered unnatural is sometimes a blurry one. There's a section in Wisconsin law, it's 8115. It provides that no action can be maintained. You can't sue anybody to recover unless a natural accumulation of snow or ice existed for 3 weeks. And there's other cases holding that shoveling or pushing snow to create a mount does not create an unnatural accumulation, so as to render, say, the city liable. So there's an entire body of law dealing with natural and unnatural accumulation. It actually is the subject of a newsletter article and a chart that we're going to be adding to our website. If you haven't been to the website, please go. It contains a consortium of charts on the laws in all 50 states, everything from contributory negligence to landlord-tenant liability to dog bite laws to you name it. It's there, and it's there for you to use. So product liability, a little bit different, and it's the area that I think is most often overlooked, and it is also the area that we might tend to pursue when there isn't justification. And it is a difficult area to subrogate in and difficult to identify. Every time a product is involved, it doesn't mean that there is potential product liability for the manufacturer. It requires you to analyze something taking into effect the cost and the benefit. And a lot of times this requires some investigation costs and often the use of an expert. Excuse me, let's say. My voice is shot, but we won 6-3. And if a product's liability case is cost effective, and this may be because if you have a $2,000 no-loss time case with some medicals, it's going to be hard to, unless you have reserves for some reason, significant reserves, to cost-effectively subrogate on a product liability case, because almost always, not always, but almost always, you're going to have some sort of expert with regard to the design of the product. You're going to want to get the product, you're going to want to get the statements, and you're going to want to try and avoid spoliation, which we've, of course, discussed, the destruction or withholding of evidence resulting in prejudice to the opposing party. Thank God for the Gulke decision. But something I wanted to point out is we've had some recent tort reform law. This is something I looked at with Representative Ott. I did not participate in, but Wisconsin Act 2 will, which became effective on February 1st, 2001, actually requires a new standard with regard to experts. It used to be that in Wisconsin, we could get an expert to testify with regard to a case, provided he had expertise, experience, and training which was above and beyond the layperson and would be illustrative and explanatory to the jury in helping them to resolve the issues of product liability. We did not follow something called the Daubert reliability rule, based on a federal case, Daubert, which dealt with the introduction of expert evidence. But effective February 1st, we now have Daubert in this state. With respect to the introduction of expert evidence, it replaces the relevancy rule, whether or not an expert's testimony is relevant to the case. And so today, by virtue of amendments to sections 90702 and 90703, this Wallstat relevancy rule has been superseded by the Daubert rule. As a result, Wisconsin, this is brand new, and it's going to affect our subrogation and our investigation of all product liability cases. And I say this for a reason. Most of my clients have a throwdown expert. And I don't mean that in a derogatory fashion. I just simply mean that they have somebody with whom they've might be nearby, might be in-house. It might be some expert that's got a bachelor's degree in engineering, and he goes out and he investigates and writes up these nifty reports. But we have to relook at which experts we use now when investigating product liability cases. As a result of this new legislation, Wisconsin judges must now serve as gatekeepers. Gatekeepers as to all expert testimony as to both relevancy and reliability of an expert. Absent any stipulation, the trial judges must conduct a Section 901A04 hearing outside of the presence of the jury to determine whether expert testimony will or will not be admitted. In that hearing, the trial judge is guided by the Daubert factors and others from cases subsequent to Daubert. The checklist in the committee notes for this new legislation includes the following. Number one, whether the expert's technique or theory has been tested. Now, as I mention these, and there's several of them here, ask yourself whether the expert that you regularly use is going to qualify. If he doesn't, you've wasted your money. He won't be able to help us. He'll be struck. And the bad thing is we won't know this until we get to trial. So in subrogation cases, you may hear from subrogation counsel, well, that's great, but we now have to follow the new law, and we have to follow these criteria, and therefore the experts you've chosen may not be enough. We have to get a new expert. And that's not good news, especially to companies like Century, who do try to tie the line, tie the rope and keep a tight lookout on expenses and attorney's fees and things like that, because experts can be expensive. But number one, the checklist on things that the judge will look at are whether the expert's technique or theory has been tested, whether the technique or theory has been subjected to peer review and publication, the known or potential rate of error, the existence and maintenance of standards or controls, whether the technique or theory has been generally accepted in the scientific community, whether experts are proposing to testify about matters flowing naturally and directly out of research they have conducted, whether the expert has unjustifiably extrapolated from an accepted premise to an unfounded conclusion, whether or not the expert has adequately accounted for obvious alternate explanations, whether the expert is being as careful as he would be in his professional work outside his paid litigation consulting. You can see where this is going. The courts in Wisconsin are trying to eliminate junk science. And that term is thrown around, but to a defendant, junk science is simply any expert that says they're at fault. To us, junk science is going to be in any case in which our expert can't find a culpable third party. So under 90702, before the expert testimony will be admitted, the trial court must be satisfied that the testimony is based on sufficient facts or data, that the testimony is the product of reliable principles and methods, and that the witness has applied the principles and methods reliably to the facts of the case. So the $64,000 question is this a seismic change or a subtle change? I'm not sure. It's too young, it's too early to know. There's been no cases that have been tried on this yet, and obviously there's no appellate decisions. But please keep this in mind when hiring an expert, and it's all the more reason to make sure we have the right expert. There's no sense in wasting money on an expert who will not be able to testify. So we have, in product liability, we have design defects, manufacturing defects, and warning defects. It's important that we obtain and secure the product. I want a statement of the operator. And sometimes the operator isn't the one who was hurt. It's important to understand how a product works. When you're investigating for any product liability, ask yourself these questions. How do I work this product? If I were there, do I know how to operate it? Do I know what to do when? It seems like a lot, but in some cases, machines are very complicated, but just getting a basic cursory overview on how a product operates can work wonders to understanding whether and when there is product liability on the part of the manufacturer. Ask simple questions. Who manufactured it? Where was it purchased? When was it purchased? Have there been modifications? Because product liability law requires that the product be in substantially the same condition as it was when it was manufactured. Get the operator's or service manual. And again, if you're going to engage an expert, I would suggest you do not get a written report. I'll tell you really simply why. A written report is nice because you don't want to spend several $1,000s on somebody and have nothing to show for it in your file. But you also want to recover. You also don't want to have your experts cross-examined and impeached on the stand because he gave an opinion without having all of the relevant facts. And I'm not suggesting his opinion is wrong, but it might be based on facts which do not include significant facts that come out later in the discovery of the case. So I always suggest get an oral opinion from your expert. Have your file documented that you're conducting an investigation in anticipation of subrogation litigation. Therefore, as we've discussed earlier, you have protected your file, you've protected your investigation, and now what you write in there, I spoke to the expert said that this product is defective because it didn't have a guard or inadequate warnings, whatever you write down, that's your report. But yet that's not going to be discoverable. So when your expert is deposed, and we always want to depose our experts without a report. I mean, we want to hold out on our experts giving reports as long as possible. We never have them, we never produce them unless and until there's a legitimate request for production under the Wisconsin Rules of Civil Procedure, at which point we have an obligation to produce them. I mean, we don't have to, but if we don't, then the other side will simply compel production of them and could obtain attorney's fees and costs, and it's additional attorney's fees and time. But unless and until they require a report, which we have to produce if requested, don't get an expert. And secondly, choose your expert carefully, especially in light of the new legislation which we just discussed. Again, we have to prove a product is defectively designed, manufactured, or marketed. Design means it was designed and it worked exactly like it was supposed to, but it's still dangerous. Manufactured means it didn't work like it was supposed to, and marketing means it was manufactured and sold and put into the stream of commerce without adequate warnings or instructions, and as a result, those caused an injury. Now, the product has to be unreasonably dangerous. Here in Wisconsin, we still are operating under section of restatement, section 402A. which means that we have a consumer contemplation case. Would the average consumer expect a cordless drill to blow up in their hand and cause them an injury? No, they wouldn't. So based on that, this would be an unreasonably dangerous condition. The defect has to be a substantial factor causing the injury. And as of right now, and I predict this will change and change this year, we do not have to prove a reasonable alternative design. If we say that the punch press was defectively designed and took off this guy's hand, and we prove that, we can win in Wisconsin. And again, product liability is strict liability in tort. We don't have to prove negligence. All we have to do is prove that the product was, see up on the chart, defectively designed and unreasonably dangerous. If we do that, we win. Now it's only a matter of proving causation and damages. But in many states, you have to prove a reasonable alternative design. That means that now your expert cannot simply be somebody with engineering experience. It has to be someone with design experience. So if you have a defective car, you can't just go out and hire a mechanical engineer to say, oh, this is a defect, and it's unreasonably dangerous. You have to have someone that can say, it's a defect, it's unreasonably dangerous, and here's the way they should have designed it. Now, what does that mean? That means you have to have someone with design experience, someone with the training and experience to help tell the jury what they should have done. And in some cases, that requires a pretty high-level expert. So again, the experts have to be chosen especially carefully now that we have these new laws in place. And I think that before long, we're going to have that new requirement in Wisconsin. Here are the definitions I gave you earlier: manufacturing defect, design defect, and marketing defect. I'll give you a couple examples. Employee killed when a bucket is attached to a backhoe. Falls, the bucket was not properly attached. The attachment is not visible from the cab. Here's the issue. Is this operator error? Yeah, there's going to be a lot of operator error. There's going to be a lot of contributory negligence in many products liability cases. But again, take off your claims hat, put on your trial lawyer's hat. If we're going to avoid leaving money on the table in the subrogation arena, we have to look at these cases with an eye toward liability. We're not going to pursue cases where there is no liability, and we're not going to pursue cases where it's cost ineffective. We'll advise you of that, but you have to look at things like warnings. In this case, was it proper for the employee to be in the trench where he was hit? Well, there was an OSHA citation issued. Now, is that his negligence? Is it the negligence of the employer? Again, the beauty of work comp, let's assume we're in a work comp scenario, is that the employer's negligence is not imputed to the employee. And oftentimes it isn't even considered by the jury. And that's true in Wisconsin. You can have a product that's 1% at fault for causing an injury, and an employer who's 99% at fault for causing an injury. And guess what? You recover 100% from the product manufacturer. Is it fair? That's a question I'll leave to greater minds than I to debate. But I will tell you that it's the law. And if it's the law, I want us to take advantage of it, because we get taken advantage of it on the liability side of things. Now, when you have construction accidents, a couple things to be aware of. Get the names of all contractors and subcontractors. You want to get copies of all the contracts and the subcontracts. You want to find out if there's indemnities, waivers, work comp coverage issues, statutory employer defenses. Don't worry about that stuff. We'll tell you whether that's in there, but it's important, I think, to get those contracts and agreements. And often the contracts dovetail into perhaps your policy. If you have certain waiver endorsements on your policy, additional insured endorsements, alternative employer endorsements, waiver of subrogation endorsements, those things all play into whether or not we have a third-party liability claim in construction accidents. We don't have this as much as Texas and Nevada and some, but you also have OSIP and CSIP, owner-controlled insurance programs, and wrap-up insurance programs that provide some interesting snags that we have to get around. Borrowed servant issues, always look into control. Find out who the injured employee was listening to, who had the right to control the details of his work on the job site. And you may want to hire an OSHA or a safety expert to help you with some of these things. When you get statements, here's just a couple of things to keep in mind. You want a written, recorded, or video statement. Again, I told you earlier, one of my tricks is get it signed or initialed. Once somebody signs it, they own it. They don't want to go back on it. They don't want to say, well, I didn't even understand what you were saying, because now they've reread it and confirmed it. Get the statements as soon as possible after the loss. While you're asking the questions, one of the things I would always ask is get the basic information, date of birth, social security number. Give me the name of a relative living in the area. Try to get somebody established, aunts, uncles, grandmothers, grandfathers, parents. Those things are good, because if this witness disappears, this is key information to help us locate somebody who can help us find that witness. And if the witness is favorable, we're going to need to find him. I would go for questions and answers. In other words, don't just say, can you tell me what happened, and let him drone on for half a page. I would go with specific questions and specific answers. Once he gives you something, expound on it. When he gives you something more, or she, expound on it. It's a great way. It's the only way to take depositions, and while narratives are allowed in statements, they aren't often as helpful unless somebody has diarrhea of the mouth. And if you think they're going to be a favorable witness, let them run on for a little bit, but don't let the statement end there. Go back and ask questions about each element of the statement they gave you, each element of their diatribe. If you have checklists, and there are some of the publications that we've had, they're available on the internet, get a checklist. It's great. I still use checklists when taking depositions, and I've been doing it 27 years. There's just certain things that you may not remember that will clue your mind into other things that have to be asked. At the end of each statement, give the witness a chance to add or change. Ask if it was true and correct to the best of his or her knowledge. Notice there's another purpose for prompt, and this is maybe one of the biggest purposes for prompt investigation and prompt action on subrogation. When you're investigating a claim and you think a government entity might be involved, understand that there are definite timelines and deadlines. We're not going to get into those today, but just understand that the city of Austin in Texas, by its city charter, requires 30 days notice, or they are not liable. Now, 30 days is a short period of time. I've rarely seen cases that are only 30 days old. So you could lose a subrogation opportunity before you ever get it if you don't give notice. And in Wisconsin, don't forget, notice has to be given in the right form, with the right information, and served in the right manner. So it often behooves you, rather than just sending a letter off, to maybe check, and we'll give you the proper form. But also give notice to plaintiffs' attorneys, third-party carriers, to claimants, and any potential defendants. Now, the work product privilege I talked of earlier, again, the key is anticipation of litigation. I want you to protect your file. And it's good enough if you just simply type into your log, I'm investigating potential subrogation and conducting investigation in anticipation of litigation. Put a self-serving memo in your file. Back when files were all paper, I gave clients a memo, a throwdown memo, to simply fill in the name of the claim number and stick it in their file. And then anytime somebody tried to recover the investigation that we had done, especially if it was harmful, we would pull out that memo, and I would be allowed to protect that as being exempt from discovery. Now, we talked about evidence preservation and spoliation. The photograph you see here is a large, the name escapes me now. It's Skipper Bud's, where they store boats, and this is down just north of Chicago. So a lot of expensive 50, 60, 70-foot antique yachts, just stuffed with boats in this place, and burnt badly. I mean, all the boats were destroyed. And there were some key questions about spoliation, because the insured went in and started pulling out things like wiring and a space heater that it had in there. And so we had some claims of spoliation. But anytime you have a fire, remember, the fire department goes in order to make sure the fire's out. They'll start shoveling out the burning embers, shovel everything into the backyard. So a lot of your evidence may be in the backyard in a big heap. We had a fire case in Germantown not too long ago involving destruction of a home and a death, and potential defendant was the battery for a laptop, and a Toshiba laptop. And we literally had to go into the backyard and take a front-end loader and load onto a truck all of the garbage in the backyard and take it to a lab where they spent weeks sorting through everything. But the defendants were just bound and determined to find something at fault other than that laptop battery. Again, we talked a little bit about this, cause and origin experts, design experts. You want the right expert at the right price. The size of the file, reserves included, dictate the quality and the price of the expert. You don't want written reports. You want to explain. Always tell your expert what you want them to say. It's not going to hurt. But because you're an insurance company, sometimes experts assume you want them to find no liability, and they want to be your friend, and they want to be hired again. So shade tree experts, shade tree mechanics have to do with guys with Bob written on their shirt. They're very good at fixing cars. They're cheap, and sometimes they make better experts, and they're more trustworthy than the guy with the lab coat. The only problem is with the new law on Daubert, the use of shade tree experts may be coming to a close, unfortunately. This is the Daubert case, the Kumho Tire case. These are now this is now law in Wisconsin. I'll just leave you with that. You've got the handout. In any type of subrogation scenario, you've got the made whole issue. I just want to remind people that just because made whole is applied in a state doesn't mean that policy language can't overrule the made whole doctrine. And in many states, a growing number of states, as long as your policy says something like this, then you will not have to overcome, or the insured will not have to be made whole before you can subrogate in most states. Now, Wisconsin is not one of those states, but many other states are. And when you actively participate in a case, subrogation counsel can monitor the case and effectively evaluate the injured claimant's damages. Discovery requests can be effectively used to limit made whole arguments at the time of the settlement. The topic of this webinar, recognizing subrogation and third-party liability, I mean, it is a rather broad brush, broad stroke that we've made with this brush. But the reason I started off slowly with some intentional proselytizing on looking at cases as a plaintiff's attorney, it's not only because I don't want you to avoid, because I want you to avoid losing out on subrogation opportunity on cases where it exists because you simply assume that someone is at fault or there's too much contrib, but also because if you wear that plaintiff's attorney's hat, your investigation will be much more effective. You will be much more attuned to the case and the facts and possible ramifications of the variables of those facts. And again, remember when you're investigating and recognizing subrogation, remember the pebbles and the saddlebags. You never stuff those saddlebags full of pebbles because you never know precisely what it is that's going to be the linchpin in cases. And I've seen a lot of cases where something uncovered in investigation makes or breaks the case. If it makes the case, I want to sell it to the highest bidder, the plaintiff's attorney. I want to get a stipulation for it. If it breaks the case, I want to bury it. I want to hide it. I want the plaintiff's attorney, if there is one, to run with it. And I don't want anyone to find out about it because our objective is to is tunnel vision. It's to move forward and make a recovery for you. So that's the end of the webinar. I do appreciate your time and attention. Looks like we're on time. And it looks like you also have a busy day today with other topics. I think we're going to be visiting tomorrow on documenting future workers' comp credits. And that will be an exciting, well, exciting. I guess it's exciting for nerds like me, but it's a great subject because until I gave this for the first time a few years ago, there literally was no reference, no resource, and the one you have in your hand is actually a lot of people don't have that. It is on our website though, so it is available. Thank you for your attention. Have a great day, and I will talk to you tomorrow.